I mean, I think that would produce the right result, because we do think that the legal standards that apply to limited public forums are the same as the legal standard we would ask the court to apply here. And here it's viewpoint neutral. The government is saying that certain types of marks can't go on the registry, or the principal register, but it is not singling out marks based on viewpoint. It is not requiring registration in order to speak the marks. I guess the two other points I would make are, for First Amendment purposes, the dispositive question is this an abridgment of speech? And so, to the extent that the court thinks it's not an abridgment of speech, we're not quite sure what it is, then we should win on that basis.
Isn't that the bottom line? I know it's almost as if we're becoming straitjacketed by labels, instead of looking at this as I do from first principles. The question is this an infringement on speech? And the answer is no. He can sell as many shirts with this saying, and the government's not telling him he can't use the phrase, he can't sell it anywhere he wants. There's no limitation on him selling it. So there's no traditional infringement. Government action always has to have a, quote, rational basis. The question then in my mind becomes, is there a rational basis for the government's activity here? And clearly, for all the reasons Justice Gorsuch pointed out, that this type of program depends on content, and that these kinds of limitations have been historically accepted, there's certainly a rational basis for the court, for the government's actions. Now, to the extent that it might involve speech, one could analogize, but I don't think you have to call it a government subsidy or call it a limited public forum. They both come out, both approaches come out to what is reasonable in this context. And that's the test you state at page 28 of your brief. You need only have a reasonable basis for what you're doing. And we don't actually talk about it in those terms in rational basis review, but isn't that the bottom line?
Yes. And
so we don't have to analogize it to one or another. We just have to figure out, is this speech, and say, no, it's not speech that's being restricted, and then look at it in the traditional lens of, is it rational basis, and is it reasonable?
And what I would say, and I think this is just a different way of saying, making your same point, is we don't think that the government subsidy cases and the non-public forum cases and the union dues cases are kind of discrete exceptions to the First Amendment. Rather, they are illustrative of a general principle that often the withholding of government assistance to speech will not constitute an abridgment of speech.
Assuming there's a reasonable basis.
Assuming there's a reasonable, and I'd also add the point that I was making earlier, assuming that the government is not trying to leverage the benefits of the program to coerce speech outside the program. And so if the statute said, when you sell T-shirts with a mark like Trump Too Small, you can't get any trademark for those shirts registered, even if the trademark you choose, like Elster Apparel, would otherwise meet the statutory requirements for registration.